Good afternoon. Welcome to today's webinar, our Civil Justice Review of the Supreme Court's just concluded October term 2021, sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School. I'm Donald Koshin. I'm a professor of law at Scalia Law School and also the Deputy Executive Director of the Law and Economics Center. I'll be moderating today's discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. Our commitment is to developing original, high-quality law and economics research and educational programs like the one you are about to participate in to further enhance economic understanding and to provide information that's useful to legal and public policy debates surrounding these issues. We thank all of you for joining us today to be part of that ongoing dialogue. Today, we have four attorneys with extensive experience litigating before the U.S. Supreme Court and analyzing its docket and practices with us. And each of their bios are available on the registration materials that you received. So I'm going to keep their introductions rather short and to the point in order to get to the substance of our conversation. First up will be Melissa Arbus-Sherry, a partner at Latham & Watkins, followed by Sarah Harris, who's a partner at Williams & Connolly, followed by Andy Pincus, who's a partner at Mayer Brown, and then finally, Aaron Murphy will back cleanup from Clement and Murphy. If you have any questions along the way, please submit your questions using the Q&A box at the bottom of your screen. Each of our participants is going to speak for about 8 to 10 minutes, and then we will take audience questions after a brief set of inter-panel discussion. Please identify yourself in your questions in the text of your message, and also keep your questions short so they can be adapted to this webinar format. With that, I'm excited to begin learning about the civil justice issues that have confronted the court this past term and what they mean for ongoing litigation and for the development of the law. So first off, we have Melissa. Take it away.
Absolutely. Thank you so much for having me. So this was a big term for a lot of reasons, but it was a very big term when it comes to administrative law. So big, in fact, that Sarah Harris and I are going to cover the topic together. I'm going to start with the major questions doctrine, which was played a prominent role this term, and really focus on two cases in particular, both of which found that an agency did not have statutory authority to issue a regulation that was at issue in the case. So the first one is NFIB versus Department of Labor. That one was decided by the court earlier in the term in January. And the second one is West Virginia versus EPA, which was decided at the very end of the term. So starting first with NFIB, what was it about? This was a case, and you may recall, it came up in January. It actually came up on the court's, sometimes referred to shadow docket, emergency docket, and it came up in the form of a stay application. Unlike most things on the emergency docket, the court actually had argument and on an expedited basis in January and came out with this decision about a week later. So this was the case about the COVID vaccine or test mandate that applied to all, or most, I should say, employers with more than 100 employees. According to the majority, that was about 84 million workers. A number of suits, as soon as this came out, a number of suits were filed by businesses, by states, by other organizations, challenging the rule and seeking a stay. All the cases were consolidated in the Sixth Circuit. And when the Sixth Circuit denied a stay, it got up to the Supreme Court. And as I just said, the court had expedited argument and decided it shortly thereafter. In a 6-3 decision, the court granted a stay. It was a per curiam decision, which meant there was no author identified. But the court basically said that, this is a rule coming from OSHA, and OSHA really is in the business of ensuring that there's occupational safety. And while COVID is a risk in many workplaces, it's just not a workplace specific risk. It's an everyday risk that you encounter everywhere. And so for that reason, OSHA exceeded its statutory authority in adopting this very broad rule that applied to so many employers and so many employees. There was a dissent that was a joint dissent by Justices Kagan, Breyer, and Sotomayor, where they disagreed. They said this is clearly a workplace hazard, even if it occurs elsewhere. But what's really significant, I think, for our purposes, or at least my purposes here, was sort of the doctrinal debate that started in this case and really came to fruition later in the term, which is really a fight about doctrine. Here, the concurrence by Justice Gorsuch named it as the major question doctrine and said, in circumstances, basically, we expect Congress to speak clearly, when authorizing an agency to exercise powers of vast economic and political significance. Justice Gorsuch named it, the majority didn't call it that at the time, but it was clearly applying the same analysis. When you have something that is very significant economically and otherwise, the court has now started to require a clear statement of delegation from Congress. The dissent disagreed both with respect to what the outcome should be, but also said, we're supposed to look at the text here. What OSHA did falls within the statutory language. And Congress does often give broad authority to agencies precisely because it can't predict the future, and also because agencies are the ones who have experts to speak on these issues. So that's NFIB. West Virginia versus EPA, again, comes up at the end of the term. This one is about the EPA's Clean Power Plant Rule. The rule was promulgated back in 2015 during the Obama administration, but it never actually went into effect. It was challenged in court. It was stayed by the Supreme Court. Then there was a change of administration. It was repealed. That got challenged. And ultimately, there was an intervening DC Circuit decision, but the Biden administration said that they were not planning to enforce it, and the court nevertheless granted cert and decided this case. So this was a regulation that was designed to address climate change in one particular respect. It addressed the existing coal-fired power plants, and it required so-called generation shifting at the grid level, basically a shift from coal-powered plants to natural gas and then to cleaner energy sources, the goal being to reduce carbon dioxide emissions. The statute is a bit complex, and I won't get into it here because I'll go well over my 8 to 10 minutes, but basically there was a section in the Clean Air Act, section 111, that the EPA had relied on that allowed them to identify the best system of emissions reduction. The takeaway, though, is less about the statutory details and again, more about doctrine. Here, unlike in the prior case, the majority officially adopted and named the major questions doctrine. It gave it that label and it applied it. This doctrine, in reading through it, it's similar to cases that have come up in the past, although it hasn't quite been given this name, but those of you may recall something called the notion that Congress does not hide elephants in mouse holes. That comes up in a number of cases and is often used, I think, by litigants. And then also the non-delegation doctrine in constitutional terms. In other words, coming from an idea of separation of powers, that we look to Congress to decide major issues. We don't want agencies essentially doing it on their own. And when we see an issue come up that is quite significant, the court is now going to require a clear statement from Congress that it intended the agency to regulate in that particular area. And so it really sort of seems from the majority opinion, it's a two-step analysis. Number one, is this a major question? Is this an extraordinary case? Is it different than what the agency has historically had done? Does it look like it's maybe a legislative workaround because Congress either hasn't done it or has refused to do it? And then if it is there a clear statement? So broad language isn't really going to suffice. You need something more particular and clear from Congress in these cases. Justice Gorsuch again wrote a concurrence, really kind of backing up the doctrine, explaining its historical support and the like. And again, there was a dissent. This was another 6-3 decision authored by Justice Kagan, who said, I had previously said that we are all now textualists. That's no longer true. The majority is basically using this doctrine as a get out of text free card, and also backing up the idea that agency expertise is important and that Congress does sometimes legislate broadly precisely because, as it said in the earlier case, Congress cannot predict the future. It also said that when the court, the cases that the majority pointed to, where you talk about elephants in the mouse holes and the like, those are ones in which agencies were acting outside of their lane. According to the dissent, this was sort of squarely within what the EPA was designed to do. And so, those are two pretty big decisions in their own respect. And as far as economics go, it depends on who you ask. What is the economic impact of NFIB, or what's the economic impact of the EPA decision? It depends who you ask. And it also depends, I think, sometimes whether you're looking in the short term versus the long term. In NFIB, just as an example, one side said, the majority said it's going to impact 84 million employees. That's going to impose costs on employers, concerns about hiring problems and the like. And on the employee side, for those who do not want to be vaccinated, it's expensive to have all of this testing. On the other hand, there were arguments that this would actually be good for businesses because it would keep America open, it would reduce workplace disruptions, as is often the case, arguments on both sides. What impact did it have? It's a little hard to know, in part because a lot has changed with respect to COVID in the ensuing months. I think things keep changing with respect to COVID, but vaccination rates have gone up generally. State localities, even the federal government has loosened some of the testing and masking requirements. And so I think it's a little hard to picture what the but-for world would have been had that gone into effect. As far as the EPA, again, arguments on both sides. The majority pointed out that EPA itself had estimated that it would cost billions of dollars to comply, that there would be higher energy prices as a result, and that it would have a significant impact, I think trillions of dollars on the GDP by 2040. On the other hand, as the dissent pointed out, that part of the reason the Biden administration had decided not to enforce it is because the industry had basically gotten there on its own already. And in fact, there were segments of the industry, according to the dissent, an overwhelming part of the industry that had supported the EPA in the case. And not to mention, as the dissent also pointed out, the sort of cost savings that could be impacted longer term when we're talking about something like climate change. I think maybe the bigger question, and again, it feels a little odd because I think those cases are very significant in their own right, but the bigger question is, what is the impact going to be of the major questions doctrine? But both giving a name to it and really kind of seeing the court start to apply it pretty significantly. And in some ways, it sort of points towards a lessening of the administrative state, which tends to suggest more deregulation, more leaving things in the hands of industry. I think it's probably not shocking to say that sometimes it is hard to get Congress to act. And also, as the dissents pointed out, it is hard to predict the future. And so to the extent the court is looking for congressional action and is looking for very specific delegation, it seems quite likely that this will lead to a narrowing of the administrative state, cause administrative agencies to maybe be more hesitant before doing something very significant that could be challenged pretty easily in court. And then I think, the big question in the years and maybe decades to come is, what's the precise scope of the doctrine? When is something a major question, and how clear does the delegation have to be? There are a lot of questions, I think, raised in that respect, and I think we'll see how it develops, as I said, in the coming years and decades.
Thank you so much. And for those of you watching, please remember you can use the Q&A box at the bottom of your screen to submit questions. With that, we'll turn it over to Sarah.
Well, thanks so much, everyone. And thanks for the invitation to talk to you guys today about a very exciting Supreme Court term, especially for administrative law, as Melissa said. These days, every term feels like a big term for administrative law. I almost feel like it's sort of a long-running suspense series where there's a new theme every season. This term being this season, the A-plot of the major questions doctrine, which Melissa just talked about. But there's also some really good B-plots this term that I'm going to cover. So one is Biden versus Texas. It's in the immigration law context, which is a fan favorite, I guess, for administrative law these days. The policy at issue is the so-called Remain in Mexico policy, which is pursuant to a statutory provision authorizing the return of someone who's arrived illegally over land through contiguous territory. So translation, if you, for instance, walked over the border from Mexico, you can be subject to a statutory provision to be asked to wait in Mexico pending your US proceedings while the backlog clears. So there's two questions in this case as it comes to the court. First of all, whether the Secretary of DHS violated the statute by rescinding this policy and thereby creating a situation in which the government could not fulfill its legal obligation to detain anyone entering the United States illegally pending deportation proceedings. And the court on that question is actually 6-3 saying, no, there's no statutory violation. And it's also interestingly, probably not the lineup you might expect when you hear the word 6-3. The chief authors the opinion, joined by Justice Kavanaugh and the three liberals. And then Justice Barrett dissents on jurisdictional grounds, but starts off her dissent by saying, I would join the merits. So that's how you get to kind of a de facto 6-3 on this. The three other conservative justices, Justices Thomas, Alito, and Gorsuch, all joined a dissent written by Justice Alito on this. So the reasoning is, I think, interesting for anyone certainly following immigration law, which is, and also just interesting as a statutory matter, which is that the authority to have people remain in Mexico under the statute says may, so that's discretionary. And then the tricky question is just, what do you do with that may in relation to a statute that overall also requires the government that they must detain individuals if they do not choose one of these options and the government doesn't have the capacity to detain. The majority solves that problem by saying, look, you can't convert the may into a must under basically any circumstances. And the dissent says it's a zero-sum game, so something's got to give. And essentially the statutory command that you must detain, you can't sort of disregard by saying you won't pick essentially the only feasible option in order to accomplish this end. So it's a sort of classic statutory debate between the courts. The second question in this case is a fairly complex question about the additional policy justification during litigation that the government gave for rescission and whether this was final agency action. Again, there's sort of a de facto 6-3 that this was okay. The two camps sort of part ways and more on how the policy is characterized, and there's some sharp jabs from the dissent in terms of the timing of the justification, but it's not really a big change in terms of how the underlying law would apply. So what are the two takeaways from this case? One, this is not the end, as is so often the case in these administrative law cases. The case goes back on remand to the Fifth Circuit for consideration of other APA issues. The rescission may well get vacated on other APA grounds. And so this is just sort of like one of the endless wars of attrition in administrative law these days. One administration initiates a policy, federal courts immediately enjoin it. The Supreme Court steps in, grants a stay or denies a stay. Administrations change. The new administration rescinds, and then there's just a new round of litigation over and over again. So we're kind of in the middle of that now with this one. And then second of all, I think this case illustrates unusual alignments on important cases are still a thing. There's lots of ink spilled this term over plenty of big 6-3 decisions on sort of conservative versus liberal grounds. I'm sure you've been reading the news. But this case is sort of typical of the justices fracturing in more unusual alignments on plenty of other cases, which was also a theme this term. So there were 5-4s in criminal law cases, in the big case involving Oklahoma, in questions with respect to the scope of states' authority on Indian reservations. And I think it shows also the added suspense in the immigration context of where will Justice Gorsuch land in any given immigration case? Because it sort of increasingly seems like for some cases, his libertarian instincts on criminal law carry over into this context, and he's more willing to join the liberals. And then in other contexts, like this case, his skepticism of the administrative state seems to prevail. And so that, I think, explains his dissent here. The other case I'm going to talk about is a plotline that I would call a fan favorite, the Lucy pulls away the football from Charlie Brown saga of Chevron. Right now, Chevron, as you may have noticed, is in the judicial doghouse. The court seems very unwilling to say in any case that the statute is so ambiguous that the agency interpretation will win so long as it's reasonable. And there's maybe even sort of like existential angst about like what Chevron is. Is it dead? Is it alive? We don't really know. People got super excited, at least people interested in administrative law in a nerdy sense, got super excited in the middle of this term by a sleeper case, American Hospital Association versus Becerra. And I do mean sleeper because it's about a statute governing how HHS sets Medicare reimbursement rates for hospitals. The DC Circuit there said the statute was ambiguous and upheld an HHS interpretation that seemed fairly out there in terms of what the statute actually said. And they rested on Chevron. The question presented was whether the DC Circuit properly applied Chevron. The petition did not ask the court to overturn Chevron, but to sort of narrow how it applies. But during argument, counsel for the American Hospital Association was pressed, if the only way for you to win was for us to overturn Chevron, would that be okay? And counsel eventually said, yeah, a win's a win. And so people got excited thinking maybe Chevron is finally on the chopping block, but that turned out to be a fake out in a unanimous decision by Justice Kavanaugh. It is most memorable, I think, for the fact that it does not use the word Chevron once, ever. It's sort of the Supreme Court equivalent of, saying the word like Lord Voldemort or something by name. Like, it's just such a dirty word these days for the court. They won't even mention it in the case. The court just said, this statute is very clear that HHS and the DC Circuit's interpretation is wrong of the statute, and we're just going to call it a day. So zooming out in terms of three things in terms of what's next. One, I think there's never been a better time to challenge agency action. Every term the court does, as sort of Melissa has alluded to, seem to add to the toolbox for challenges and really express, I think, skepticism, whether it's a Republican or Democrat administration, of what the agency is doing and how far it can go in terms of enacting changes that seem fairly like a radical break from the past. Second of all, I think we are going to see, especially next term, and this has been a persistent theme, a return to focusing on the separation of powers and sort of fundamental questions about how do you structure these agencies at all and how accountable do they have to be to the president. That's always lurking in the background, and I think could be a source of fairly significant changes going forward, or at least a perennial area of interest. And then third, just one sort of thought on all of this, which is, it's obviously hard to welcome the endless gridlock of administrative law trench warfare in the courts, but there's an argument for a silver lining, which is that I think the days are gone in which agencies could issue 10-page proposed rules or develop half-baked legal interpretations and depend on Chevron or other doctrines to always win. So I do think there is more accountability coming for agencies in ways that may produce good government. You can debate whether you think there's too much of a good thing in terms of accountability and it's too hard for agencies to do rules. But I think, there are legitimate questions about how good were the old days in all events.
Thank you very much. Before we move on to our final two panelists, I want to pose something to our team admin law, our first two presenters, as well as allow both Aaron and Andy to chime in as well if they'd like, recognizing that we do want to get to the other presentations. But quickly, maybe a minute or less from each of you, could you explain whether there is a difference, and what, if so, what it is between the major questions doctrine and the non-delegation doctrine? I will note that we had a program here as part of our judicial education program where a number of judges were very interested in getting down to how to distinguish those. And I do think that perhaps I'll start with this: is it the case that something could pass the major questions doctrine test but still fail non-delegation? And could that work in the reverse? Could something fail non-delegation but satisfy major questions? Those are just some of the questions I think that are on the minds of people trying to figure out and reconcile these two doctrines. So either Melissa or Sarah, do you want to start with that?
Yeah, I'm happy to start. I mean, this is my take. They're quite related to one another. One difference is the non-delegation doctrine has just not been used in a very, very long time. And while it's, some justices, Justice Gorsuch, sort of support its resurgence, it is a constitutional doctrine. So it's sort of more about what can Congress do versus what did Congress do. And so the major questions doctrine, I think, kind of gets at the same thing as far as separation of powers goes, but does so in the guise of statutory interpretation. So more focusing on, did Congress actually give this authority to the agency versus whether it was okay for Congress to do so as a constitutional matter. As far as analysis goes, I mean, the reality is the major questions doctrine gets you to a clear statement rule. And so I think maybe, the question you asked depends on whether the clear statement rule would sort of necessarily provide the clear and intelligible principle you need from Congress in order to survive a non-delegation challenge. And I could see maybe some daylight between the two, but not a ton. And then just to throw one more doctrine on there, I mean, it sort of, in my mind, also has a little constitutional avoidance going on, that if we look at a statute and say this is a really big issue and the statute's not clear enough, so we're going to say that an agency doesn't have statutory authority. In some ways, it helps avoid a non-delegation question and kind of skip that constitutional avenue in a way of deciding. And one other thing is just sort of to go back to what Sarah was saying, there's all these different tools, I think, in the court's toolbox now to say that an agency can't do something. And in some ways, the major questions doctrine allows them to skip the Chevron problem, because if you find that the agency doesn't have authority and or you find that the statute is clear, you never get to Chevron step 2. And maybe it also, on the flip side, helps the court avoid the non-delegation doctrine.
Yeah, I would just add, I think it's unclear. One of the many major questions about the major questions doctrine is it going to merge into non-delegation or not? I mean, I think Justice Gorsuch's concurrence sort of suggests, yeah, there's kind of a non-delegation-y feel to it. I think right now the main difference is Congress can have a super clear statement like, hey, agency X, we would really love it if you ran the national economy. And it could be extremely clear, but I don't, in terms of an intelligible principle for running the national economy, I think you would be missing that for non-delegation purposes. So while there may be technical differences, like Congress doesn't really write statutes like that. So I agree with Melissa. It seems like an avoidance tool for now for the major questions doctrine, but I think the court is so interested and is going to have so many challenges and so many opportunities to develop more what the doctrine entails that I would say stay tuned, because I think, as we know from previous terms, they are very interested, I think, in also just figuring out what does the non-delegation doctrine actually mean, and what should it mean, because it's been buried for so long.
Aaron or Andy, any thoughts?
Sure. Yeah. I mean, this isn't radically different from what you've just heard, but I've always kind of thought of the major questions doctrine as its own way of revitalizing non-delegation. I mean, the court really would like to revitalize non-delegation, but it's a little bit hard to figure out precisely how to do that. It's one of these things that just works a little better in theory than in practice. Frankly, I think there's, a little bit of elements of that to the major questions doctrine, because, it was a kind of a perfect opinion for the Chief Justice to write, because he just is very good at just sort of saying these things that sound very common sense and reasonable without exactly articulating precisely what the limits and contours of the doctrine are. And I think Justice Gorsuch tried to put a little more meat on those bones. But I think both non-delegation and major questions are sort of built on that premise of like there's an instinct that there's just some stuff that it doesn't make sense to think that Congress is delegating, and also an instinct on this court that even if it is pretty clear Congress is delegating, we're still going to, work very hard to conclude that they didn't. So I think that the major questions doctrine, in the best understanding of what is sort of the substantive grounding for it, really is grounded completely in the idea of having a constitutional avoidance doctrine built on non-delegation. And if you have a robust major questions doctrine, you may never need to get to the non-delegation issues in the first place.
Thanks so much. Andy, I can just let you answer that question if you have any thoughts on it as you transition into your topic. We're going to go to Andy next and switch to arbitration, but feel free to start with anything you want to say about admin law. And I'll remind the audience that we also have the Q&A box at the bottom of the screen. We should have some time at the end for questions, including additional ones on administrative law, but I'm quite certain that you're going to start wanting to ask about arbitration after you hear the next two presentations. So Andy, over to you.
Thanks, and thanks to be here. I guess what I would say about the last question is there may be remedial differences. Non-delegation may mean that the entire statute is unconstitutional. That could have broader consequences in terms of the agency's regulatory authority. It also could have broader consequences in terms of the preemptive effect of the statute if it has any disappearing along with the delegation. And I can't resist following up on what Sarah said about Chevron, to say I sort of think of Chevron as a zombie. It's sort of a dead man walking around the Supreme Court, but no one can talk about it. And for some reason, it hasn't yet been properly buried. But why don't we transition from administrative law to arbitration? Because to me, there's nothing more interesting than arbitration, and apparently to the court too, because it was a big term for the Federal Arbitration Act. There were 4 cases this term. I think going into the term, opponents of arbitration thought this was finally the term where there were going to be limits on the FAA's reach, ending what they perceive as a string of pro-arbitration rulings. And I think arbitration aficionados probably anticipated some considerable expansion of prior FAA rulings. But the court really did neither. If you look at the cases, it issued unanimous or virtually unanimous decisions that ruled quite narrowly. We've had some polarized 5-4 decisions in the arbitration context. This term, every single decision was either unanimous or virtually unanimous, with the justice not doing so on reasons that really didn't relate to the, except in one case where Justice Breyer dissented, that really didn't relate to the substance. So I guess the bottom line is pretty broad acceptance of the court's FAA precedents, narrow rulings that resolve some questions, but I think, as we'll talk about, that leave open a bunch of questions that are going to result in a lot of additional litigation, and probably these issues coming back to the court in somewhat different contexts. I thought I would talk about the Viking River case. Viking River involved the application of the FAA to a rather peculiar California law called the Private Attorneys General Act. It's a law that says an employee can bring a lawsuit to recover the civil penalties that would ordinarily be enforceable by the California Labor Department, not only for violations that she alleges that she suffered, but also penalties for the same or different violations relating to any other employee in the company. The employee retains 25% of the penalties, 75% are paid to the state, and the plaintiff's lawyers get attorney's fees. Any company with employees in California is likely to be familiar with these cases. PAGA was a sleeper before the Supreme Court decided AT&T versus Concepcion and ruled that class waivers in arbitration agreements are protected and enforceable under the FAA, regardless of state law. Before that, plaintiffs' lawyers had tried to use class actions to avoid arbitration agreements. With that route blocked by Concepcion and the subsequent decisions in American Express and Epic Systems, California lawyers at least seized on PAGA actions, and the number of actions filed went from essentially negligible to many per day in terms of the notices that were being given to the California Labor Department, and cases being filed with one employee asserting claims on behalf of tens of thousands, and in some cases even hundreds of thousands of employees. So pretty massive cases. What did the California courts do with PAGA actions and arbitration? Well, not surprisingly, perhaps, the California Supreme Court held unenforceable arbitration agreements that limited PAGA claims to the violations affecting the claimant alone and barring the claimant from asserting violations experienced by other employees. And both the California Supreme Court and the Ninth Circuit then went on to hold that the FAA principle protecting individualized arbitration did not preempt that state law rule. So there were a number of efforts to get this PAGA question before the Supreme Court. A bunch of petitions were denied, but I think the court saw the volume of PAGA cases going up and granted review in Viking River. And the court reversed, with only Justice Thomas dissenting based on his view that the FAA doesn't apply to actions in state court. A large part of the argumentation in the briefs was that PAGA claims, especially these massive PAGA claims, were just like class actions, and therefore should be an arbitration agreement provision limiting them to only the claimant's claim should be protected for the same reason that class action waivers were protected. But the court, speaking through Justice Alito, didn't agree with that. It said, no, these aren't the same as class actions. They don't present the same due process issues about absent parties, and we're not going to apply our class action principle here. But the court said, we're going to apply a different FAA rule. The FAA allows parties to decide what claims they want to arbitrate. And the California state law rule basically created an all or nothing rule regarding arbitration of PAGA claims. The court said the only way for parties to agree to arbitrate one claim would also to agree to arbitrate all PAGA claims. And that limitation of freedom to contract was incompatible with the FAA. So the court said, looking at the arbitration agreement before it, provided for individualized arbitration. Therefore, the PAGA claim relating to the claimant's own labor violations was arbitrable. And then the court said, what are we going to do with respect to these PAGA claims that she asserts with respect to other people? And the court concluded that those claims couldn't proceed in court as a matter of California law because California standing law barred actions where the plaintiff was not asserting a claim on her own behalf, and it directed dismissal of those claims. Justice Sotomayor wrote a concurring opinion and said, I just want to flag for everyone that the court's state law ruling on that issue could be wrong. It might be corrected by the California courts, or if it's right as a matter of California law, the California legislature could change the rule. So plaintiffs' lawyers have seized on that concurrence and said it will be easy for them to end run Viking River by having a plaintiff file a lawsuit in court asserting only the claims involving other employees and then arguing that that claim is not subject to arbitration. We've spent a lot of time looking at this, I think, as of a lot of lawyers on the defense side, and it looks like, not surprisingly, Justice Alito got California law just right. The labor code expressly requires an employee to bring a claim on behalf of himself or herself before being able to represent others. And also, people may remember that California voters expressly rejected lawsuits without injury to the plaintiff in the context of the state's unfair competition law when they passed Prop 64. So it seems pretty unlikely that California courts are going to allow these lawsuits to proceed. And even if they did, Viking River doesn't say there's no FAA preemption in that context. It doesn't address the issue. So it seems likely if the case came back to the court with California law permitting these sort of headless PAGA claims, that the court would say that the protection of individualized arbitration and the FAA rule that people can agree to resolve all of their claims in arbitration would require preemption of a California law rule that allowed those claims to escape arbitration. So an interesting case, and I think an example of what happened in some cases this term, which is the court wanted to rule narrowly and get a broad majority, and the price of that broad majority was not fully addressing all of the federal issues that were presented in the case. So with that, I'll turn it over to my team arbitration partner, Aaron, for some more arbitration.
Thanks, Andy. As you recall, we have the Q&A box at the bottom of the screen. Please submit any questions that you'd like us to pose to the panel at the end of this, at the end of the final presentation. So with that, we'll turn it over to Aaron Murphy.
Great. So I'm going to talk about a couple of cases, kind of continuing on Andy's theme that, I think at first blush, I mean, that they are the rare cases where the party asserting arbitration lost, but I'm not sure that that's, really reflective of some broader trend or really big news so much as just the way the court decided these particular cases, because they were both decided in really pretty narrow and, for one, extremely narrow ways that leave quite a bit out there still to be decided. The first is a case called Morgan versus Sundance that involves something that actually comes up quite often in litigation, which is what happens if if you've gotten arbitration with agreement with somebody and they sue you and you don't invoke the arbitration agreement at the very first moment possible once you get sued. And it happens a lot. Sometimes people, they might not realize at first that they had the arbitration agreement, things might be going on. So, just some filings happen. Sometimes it happens for more strategic reasons that people intentionally take their time. But over the years, the courts have developed pretty much a consensus in the lower courts that it is okay if you didn't invoke it at the first moment, as what they're going to do is look at whether the other side was prejudiced by the amount of time that it took you to invoke it, whether you waited so long that they engaged in a lot of litigation, spent a lot of money, things like that. A very small circuit split developed, and there was an opinion suggesting maybe the consensus was wrong, and the court took up this case. The case came to the court with a cert petition that really presented the issue as sort of like a reverse weaponizing of the equal treatment rule. There's normally the rule that arbitration is subject to the same equal treatment as any other contractual rights. So states can't treat it worse than they treat other contractual rights. What the petitioner said here is, this is actually an instance of courts treating arbitration better than they're treating other contractual rights, because normally if you have waived a contractual right, you don't look at whether there was prejudice. Waiver is, sort of the end of the story, and you can't get the right back. So I think the court took the case thinking, that this would be just a nice way to say the equal treatment rule goes both ways. My firm represented the other side in this case, and among the arguments we made, we spent a lot of time arguing that this really isn't waiver. Waiver requires the intentional relinquishment of a right. And that's not what you have going on when a party doesn't say like, no, I never want to arbitrate. They just kind of don't invoke the arbitration agreement at the earliest moment. At most, you would think of that as forfeiture, and forfeiture does require prejudice. So we basically said, look, the lower courts are getting this exactly right. They just are using the wrong terminology, which prejudice and waiver and forfeiture get mixed up all the time. The court ended up issuing a unanimous, extremely narrow, and frankly, I think a little bit kind of goofy opinion in the case. What they said is, we're going to assume without deciding that this is waiver. And on the premise that it's waiver, it would be a violate this equal treatment rule in the other direction, and courts shouldn't have a prejudice standard. But we're not resolving whether it's waiver. And really, you're free to continue arguing that actually it was forfeiture, and actually the lower courts were getting it right all along. So they seem to have taken this case and accomplished like very little when it comes to actually telling parties whether you do need to assert arbitration at the earliest moment. At most, all the case really established is the equal treatment rule does, at least in some contexts, seem to sort of go both ways. Equal means equal, not necessarily a most favored nations kind of view of arbitration. But I think it really leaves on the table, a whole host of arguments that can continue to be made by defendants in the position our client found themselves of having not raised the arbitration agreement at the earliest opportunity in litigation. The other case that the court decided that kind of went in the so-called anti-arbitration direction, but somewhat narrowly, I think, is Southwest Airlines versus Saxon. So this is a case about an exemption provision in the Federal Arbitration Act, which exempts contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. The question here was whether that exemption covers workers who are engaged in loading and unloading baggage and other cargo on planes that are traveling in interstate commerce. The plaintiff here was what's called a ramp supervisor. So she engaged, she supervised loading and unloading, but she also unloaded and loaded herself, which was important to the court in the way it resolved the case. She had brought a putative class action under the FLSA saying that she was owed overtime. And the question arose, whether she qualified as, and she and the class qualified as a class of workers engaged in foreign or interstate commerce. She argued that the court should really define the relevant class of workers by looking to the nature of the employer rather the employee. So she said basically, since the airline is engaged in air transportation, and that's an industry that is engaged in interstate commerce, really all airline employees should be covered, whether it be, cargo lifters, shift schedulers, or as the court said, those who design the airline's website. The court rejected that broad reading of the kind of conception of class of workers and said, no, what we need to do is look at what an airline employee actually does and whether that involves interstate commerce. On the flip side, the airline argued for a pretty narrow understanding of what it means to be engaged in interstate commerce. It basically said it should only be things, it should only be people who are themselves kind of physically moving the goods and certain whatever it may be across the foreign, the international boundaries, the interstate boundaries, whatever it may be. So things like the pilots, the crews, those who are operating interstate commerce. The court rejected that narrow conception of the class of workers too, and instead said, relying on some kind of longstanding precedent, that at a minimum, the loading or unloading of things that are just being loaded for interstate shipment is, as the court put it, so closely related to interstate transportation to be practically a part of it. And so the court said that an airline employee who's physically engaged in that loading and unloading does qualify as a part of a class of workers who are engaged in foreign or interstate commerce. But what's interesting, about the way the court resolved this case, what made it narrow is, the court, for one, went out of its way to emphasize the fact that Ms. Saxon was a ramp supervisor, and that even though she was a ramp supervisor, she was engaged in loading and unloading, and it reserved judgment even on the question of if you had a supervisor who was supervising the loading and unloading, but didn't spend their own time unloading and unloading, they would qualify as part of that class of workers. So even as to this, the particular class they were dealing with, they said, we're not even saying that they are all necessarily in based on sort of the job titles. We're really going to look at the particular responsibilities they have. And the court made clear also that they had an important caveat where they said kind of like, if you're dealing with someone who's further removed from the channels of interstate commerce or the actual crossing of borders, they declined to decide whether they would qualify too. So they provide examples of things like food delivery drivers or the kind of last leg deliverers for Amazon who are doing, the last piece of getting it to you rather than being the ones who deal with the interstate shipment. So ultimately, when you look at this opinion, yes, it is a victory for the employer who didn't want to be bound by an arbitration agreement. On the flip side, I read the court's caveats as saying this really isn't a victory for anyone other than those engaged in the specific act of loading and unloading cargo that is part of interstate commerce. And we're really leaving for another day all of the kind of difficult questions about as we get even a little bit more removed from that specific activity. So to Andy's point, it certainly wasn't, these certainly aren't decisions that are part of a pattern of kind of the robust pro-arbitration bent that we've seen from this court in recent years, but I would be very hesitant to read them as reflecting some kind of retreat from that perspective. They really just seem to be more cases that are grounded in basic principles of statutory interpretation. As to Saxon and as to Morgan v. Sundance, it really just has the flavor of a one-off case that came late in the term and the court found an easy way to unanimously get rid of it.
Thank you very much, Erin. I want to take just a couple minutes to see if anyone has any reactions to the other panelists' comments or anything you want to add before we move to questions. All right, seeing none, let me toss out sort of a mix of a couple themes that we see in some of the audience questions. And that's the audience seems interested in whether or not there were any justiciability issues decided this term and what it might mean for ongoing litigation. One particular issue was raised as the justiciability in West Virginia versus EPA. Another question asks about the civil enforcement statute in Texas. And we promised our viewers that we'd stick sort of to civil justice issues and not get into the deep dive of all the hot constitutional issues that were happening this term. But certainly that civil enforcement case could have implications across a number of different statutory possibilities on the part of state legislatures. So any thoughts on justiciability generally or about the Texas civil enforcement regime?
I'll start on the first and skip the second for now and let others weigh in. I mean, the justiciability issue in the EPA case, I mean, one thing that's kind of interesting is the court did address it and said, we can address this issue. And even the dissent said, yeah, it's probably not, maybe it's not moot, or at least didn't go down the road of saying it was technically moot, but did call what the majority did an advisory decision. I guess, in terms of narrow decisions versus broader decisions, the court has at times issued rulings on justiciability that allow them to basically avoid deciding the merits of a case, what might be a really big decision. And I think in prior terms, we have seen that in a variety of different instances where cases have gone off on standing or other grounds and the merits have been kicked to another day. And at least with the EPA, that was not the case, with the EPA decision. And it could have been, I mean, what the dissent said is you could have just not granted cert since the rule wasn't being enforced. And so I think there are ways, whether it's justiciability or denying cert, where the court can decide things more narrowly. It sounds like in the arbitration context, there are some more narrow decisions to gain greater consensus. But I think this term, maybe more than some more recent ones, there was a little bit less of that.
Any other thoughts on those issues?
I think it's a court that's concerned about those issues. In the case that Sarah talked about, there was a pretty rigorous debate about the scope of this statutory limit on courts' power to decide various immigration issues. And I think, just to point out a development from yesterday, newsrip from the headlines, the court granted review in another immigration case, a challenge to the Biden administration's immigration enforcement priorities, and directed the parties to brief not just the question about whether or not that's reviewable, but also standing and justiciability based on this same immigration limit. So I think it's a court that's concerned about these issues. If you remember a couple of terms ago in the Obamacare case, people thought that would go off on a statutory construction grounds, and it went off on standing. So I think we haven't seen the last of where this court may be on standing.
I just jump in and say, I think it's particularly interesting in the administrative law context right now because of the fallout from shifted administrations. And I think the best example of that is actually the court dismissing as improvidently granted the Arizona versus City and County of San Francisco case, which is hopelessly complicated, but involved a bunch of states led by Arizona trying to intervene to defend and essentially have operative the so-called public charge rule, which the Biden administration had repealed during the course of the litigation. So it was just super complicated. And the question as it came to the court was, can these states intervene? And you could tell from the argument that justices were really, really struggling with, like, how do you deal with, the posture of a case and its justiciability when there might not be a rule, there might be a rule going forward. It was just, and I think that's going to keep coming up because they were very, very troubled, I think, by the idea that the government could essentially unilaterally get rid of cases that the court wanted to address the merits of by simply sort of revoking the rule without public comment. And I think the court's going to keep struggling with this, like what to do with this, especially if we're in a world of, the continued war of attrition between one administration does X, the other one does not X, and perhaps a future administration tries to do X again.
Yeah, just to jump in with a quick, just to pick up on what Sarah said, I think the justiciability issues come to the court in two kind of different postures. And I think that the posture dictates a lot where the court thinks about it. There's cases they take like to resolve justiciability issues, things like the TransUnion case from a few years ago, where they're thinking about standing and the limits of when they think courts should be able to get into cases. When justiciability arises more in the context of things like mootness or things like where the court feels like parties are trying to prevent the courts from being able to resolve issues that they do think belong in the courts, I think the court has a very different reaction. And those two things can be in some tension because I don't think the court wants to develop kind of bad law in the later context that will impact the law that it considers good law in the former context of limiting kind of the role of the federal courts as a general matter. At the same time, particularly when you get to cases arising at the Supreme Court, I just think this court has always had, a really negative reaction to the idea that parties might be engaged in a little bit of gamesmanship to keep the Supreme Court from being able to resolve questions, which is, arguably in tension with the court's whole, particularly in tension with the fact that I think the Chief Justice hates that in particular, even though he's sort of the, champion of judicial minimalism, which is all an interesting tension in and of itself to explore.
So let me turn to an audience question that's rather specific in the arbitration context, and a question as to whether or not the court even addressed anything related to the affirmative defenses under the federal rules. So a failure to timely invoke arbitration, is that waived under the same concept as an affirmative defense under FRCP 8C? And is there anything from this term that in the cases you've discussed which might shed light on that?
Yeah, so this was at issue in the Morgan case. The arbitration is not identified as affirmative defense that has to be raised under Rule 8, which was part of our argument about why, look, if you want to make it, if you want to put something in the federal rules that says there's a particular time you have to raise it, go right ahead. But in the absence of any federal rule that says that it has to be raised at a particular time, you kind of shouldn't be making up rules after the fact to say that parties are at fault for not having raised something when no rule requires them to do so at a particular time. So it can be raised as an affirmative defense. It can be raised, arbitration can be raised in a variety of different ways. And ultimately, I don't think this opinion sheds any, unfortunately, light on exactly when the court thinks it should be raised. But it seemed to me, if you take the takeaway from some of the questions and arguments and all that, is my sense is the court doesn't think it actually has to be raised at the absolute earliest opportunity. But the earlier the better.
Yeah, it was striking, as Aaron said, that once that case got to the oral argument stage, whether the question was decided would be decided based on state law or federal law. If it was federal law, was it the FAA? Was it waiver, forfeiture? Did the federal rules have a role to play? Didn't Justice Kavanaugh say something at the argument? Well, in the DC Circuit, here's our rule. Maybe this is a good rule. It was really all over the map about what might govern. And as Aaron said, since the opinion doesn't actually address that fundamental question, it's all still open.
Interesting. All right, so we are near the end of our hour, and I'd like to reserve these last 4 minutes to ask each of you to reflect on the future. So this was a Supreme Court review, but while we have this group of experts assembled, I can't help but ask you, what are you looking at in the coming term? What are you watching, either in terms of cases that are currently pending a cert review answer, or petitions that are pending, or cases that have been accepted that you're particularly excited about watching and seeing what happens? So any predictions for the future? And you can also use this time to address how you think the lower courts might be reacting to some of the current decisions. So why don't we go in reverse order and start with Aaron?
Sure. So, I've certainly got my eye on a pair of cases, one of which my firm's handling, Axon and Cochran, which are both in the administrative law context, and they involve basically the question of, we've had a lot of cases over the past few years where the court has vindicated separation of powers principles, like the removal powers of the president and some of those doctrines. And the question here is essentially, can you raise those kind of structural constitutional challenges to an agency as a kind of a pre-enforcement challenge, essentially? Right now, most of the doctrine says you have to wait and run the whole gamut of all the agency procedures before you can ever, at the end of the process, say, hey, I think this agency is unconstitutionally structured, which as a practical matter means a lot of these cases either never get there, or by the time they get there, there's not much you can do to unscramble the egg. So the question here is, can you bring those challenges at the threshold to say, I think the FTC or SEC, the agencies that issue here, is unconstitutionally structured and should not be able to kind of take action against me in the first place.
Andy.
Well, I'll say something about administrative law too. I think this could well be the term where the court's focus shifts a little bit from the rulemaking context to the adjudication context, administrative adjudications. It's been for decades, agencies have had a choice typically between proceeding civilly in court or through their own ALJ process. The Fifth Circuit decided a case last month called Jarkissi, where it basically found 3 separate constitutional defects in the SEC's administrative adjudication context: the Seventh Amendment jury right, a non-delegation problem, and a removal limitation problem. And although the government's petition for rehearing, my guess is that's a case that's almost certainly headed to the Supreme Court one way or another. And I'll put in mention a case our firm is handling called National Pork Producers that deals with the Dormant Commerce Clause. With federal power perhaps constricted, what will the states do? California enacted a law that says that if pork sold in California has to be produced in a humane way, no matter where it's produced. And the question is that extraterritorial regulation or otherwise impermissible under the Commerce Clause? Because it governs 99% of the pork that's sold in California is raised elsewhere.
Thank you. Sarah.
So one prediction and then one case I'll talk about. The prediction is the court is going to keep leaving room on its docket for things that come up in emergency posture to migrate over. I mean, we just saw that last week, or I guess yesterday, not even last week, when the court has added a new case to its docket for December already with respect to whether the Biden administration's immigration enforcement policy is permissible. So I think that may just be a trend that we keep seeing in future terms, which will affect, I think, the balance of merits cases too that get granted. And then two, as a case that I think is really interesting to watch is the Norfolk and Southern personal jurisdiction case. That may sound like a non sequitur. I'm personally interested in personal jurisdiction. And the reason is, I think a lot of people had been thinking the court was tired of personal jurisdiction. They had granted a bunch of personal jurisdiction cases, but this one raises a really fundamental question about, can states essentially preemptively require you to consent to personal jurisdiction as a condition of operating in the state? How much of a waiver of how much leeway do states have to impose these kinds of waivers? So it's kind of just a nifty conceptual question. And it's also one where I feel like the conservatives are going to keep testing the waters of what comes next for personal jurisdiction, because some of them I think have expressed questions about where does the whole sort of due process minimum context test come from anyway? So it could be an area that gets even more interesting.
Thanks so much, Melissa.
I am last, so I will be really quick. I won't talk about any cases, but I actually do think that personal jurisdiction one is definitely one to watch. I think it's also indicative of sort of seeing how certain areas of the law start to transform. And so I'll end with admin law. More generally, I think we will see a lot more in the coming years as sort of the admin law, at least I learned in law school, is starting to shift and change a bit. And so whether it's through, Chevron or through the major questions doctrine or, through finding text to be more clear than it maybe otherwise would have seemed, it'll be interesting to see how that develops.
Thanks so much. And while there's so much more to talk about, we do try to keep these programs to an hour to be mindful of our audience time. So we will end for today. I want to thank all of our panelists for bringing their expertise to bear on these questions of what's happening at the Supreme Court, both in the past term and what we expect in the future. You've been tuning in to a webinar from the Law and Economics Center at George Mason University's Antonin Scalia Law School. If you'd like to learn more about the programming at the Law and Economics Center, please go to masonlec.org. That's masonlec.org. You can see all of our upcoming programming listed there, as well as if you'd like to support these programs, all provided as a public service, there's an opportunity to do so at masonlec.org as well. I will note that we do have a Supreme Court preview coming up in September. I invite you to join in at that webinar, as well as attending some of our other programs that are listed there and that will be listed in the near future. So with that, I thank all of you for participating in this audience, as well as those panelists. Thank you to all of our panelists. And I look forward to seeing all of you again at a webinar or LEC event soon. Have a wonderful weekend, everyone. Take care.